Thank you, Ben, and thank you to our practitioners for doing all the important work that you're doing and continuing to do. Appreciate you having all of Carleton Fields. It's a pleasure to be here. So let me start by giving a brief background about what civil liability is, and I think you received a few handouts before the presentation, but I'll go quickly over it. So civil liability is usually what we think of when a lawsuit is filed by a party suing for money, what lawyers refer to as damages. This is different from criminal liability, where cases are brought by a prosecutor, someone with the district attorney's office or the U.S. attorney's office, for example, to redress a public wrong, and that potentially could result in imprisonment or jail time. Now, within civil liability, there's what we call contract law and tort law. Contract law is designed to impose duties on parties who enter into a contractual relationship, whether that's a written agreement or an oral agreement. Tort law, on the other hand, imposes duties on the members of the community as to socially acceptable and responsible behavior. And so today we're really focusing on tort law and specifically negligence. In other words, can a prevention practitioner acting in good faith or trying to do the right thing be liable for what a participant or patient does to a third party or the patient, him or herself? Now, I've put up on the slide the elements of what is needed to assert a negligence claim under New York law. Although these are negligence principles that are general in nature and they manifest in most jurisdictions across the United States, as with all these concepts, the law may differ from state to state. So under New York law, in order to prevail on a negligence claim, a plaintiff must show four things: the existence of a duty, breach of that duty, causation, and damages. So on the next slide, I have put up the threshold question in any negligence action, which is whether the defendant owes a duty of care. Now, you may be thinking, what exactly is a duty of care? Well, it simply means the legal obligation which is imposed on an individual or an entity that requires adherence to a standard of reasonable care while performing any acts. And the next question after that is, when does a duty of care arise? And the existence of a duty of care is really a policy-driven decision made by judges. And it usually involves a balancing of interests. And in New York, there's a few that they have listed for you on the slide there. And it's really to ensure that the courts don't open the floodgates to litigation, but at the same time, they're appropriately protecting the public and imposing standards in the interest of all those involved. So then when you're thinking about a duty of care, how does that apply in the prevention practitioner space? So on the next slide, there's the initial question is, does the duty of care mean that practitioners have a duty to control the patient or the participant's actions? And if we go to the next slide. So I will say that New York courts have been cautious in extending liability to defendants for their failure to control the conduct of others. And that's true even where, as a practical matter, the defendant can exercise control. And this grows out of the concern, which I kind of spoke of earlier, of potentially limitless liability and about the unfairness of imposing liability for the acts of another. But courts have imposed duty where the defendant does have actual control over the third party's actions, or the relationship between the defendant and the plaintiff requires the defendant to protect the plaintiff from others. And this bears out in some examples. I would note that many states follow the restatement approach. So again, while New York law is the focus of our case law and some of the principles, you'll find similar case law in other jurisdictions. So in the first case that I've put on the slide, it involved an outpatient alcoholism clinic. And there, the patient had not been admitted to the hospital. And ultimately, the court held that the defendants did not owe a duty to control Vasquez's conduct. Again, it was outpatient. So because there was no measure of control, that they had no duty to control either. The court also held that the defendants acted reasonably by telling Vasquez not to drive, and that the court said that the defendant could not be liable for taking additional steps beyond telling the patient not to drive to prevent him from driving. And the court stated that it was common knowledge that one should not drive while intoxicated. So putting in reasonable measures of protection, but also kind of evaluating how much control you have over the patient informs how much of the duty that you have. And then on the next slide, I've put up another example of, again, a voluntary outpatient program. But here, the defendant did have a measure of control over the patient's actions. And so liability was imposed upon the state for, this time, failure to hospitalize a patient. The patient had a history of being in and out of inpatient treatment, and the doctor there had an opportunity to place him on inpatient status when the patient made an office visit for treatment. So again, where the practitioner has a measure of control over the patient, there was a duty to control the patient. And then similarly, in the next case, Winters, at issue was the defendant's hospital's decision to release the patient, who later killed the plaintiff's decedent. It was the estate suing the hospital. And in deciding that the court held that the liability can be imposed for releasing the mental patient because there the patient was exclusively in the control of the medical provider. And so again, where the hospital had control over, leave privileges, for example, the hospital had to, and the practitioner had to exercise reasonable care in exercising that decision. There's a caveat and a hurdle that the plaintiff has to overcome, and it's on the next slide. It's basically a standing issue, which means that not everyone is owed a duty of care because New York law says that there's no general duty owed to the public at large. So it really matters who the plaintiff is, who's suing, and what the relationship is between the plaintiff and the defendant, or here the potential practitioner. The next major duty that I'll mention, other than the duty to control, is one that I think you're probably at least familiar with as practitioners, is the duty to warn. Now, the duty to warn comes from the landmark case from the California Supreme Court, and that's Tarasoff versus the Regents of the University of California. There, the California Supreme Court held that the mental health providers had an obligation to protect persons who could be harmed by a patient. And what that means is that mental health professionals must use reasonable care in informing authorities or warning potential victims. This is what we refer to as the duty to warn, or by using whatever means deemed necessary should the practitioner determine that the patient poses a threat to a third party. Now, most states have laws that either require or permit mental health professionals to disclose information about patients who may become violent. And again, it's sort of a matter of state law. So there are going to be differences between each state on, sometimes they're going to be permissive, basically saying that you're allowed to disclose certain things, but then there's other states that will tell you that you have to report in certain circumstances. And irrespective of whether it's mandatory or permissive, it's important to at least be cognizant of what those responsibilities are, those expectations are, so that you're meeting those standards. All right, so then New York, I want to go into specifically the duty of care. And that's on the next slide. Oh, actually, if you could go back. Yeah, so New York's duty to warn is codified in mental hygiene law 9.46, which requires a mental health professional who has determined that a patient presents, and this is the key language, a serious and imminent danger to himself or others, to report. And this section imposes a mandatory duty to report while protecting mental health professionals who discharge that duty in good faith from both civil and criminal liability. So some of the common questions are, who is required to report under the section, and extends to mental health professionals defined as 4 professions: physicians, including psychiatrists, psychologists, registered nurses, or licensed clinical social workers. The exception to the requirement to report is if, in the professional's reasonable professional judgment, a report would endanger the patient or would increase the danger to the potential victim or victims. And so again, the requirement sort of requires the professionals to use judgment and do an assessment of all of the circumstances at play. The standard to report is likelihood to result in serious harm, which can mean threats of or attempts at suicide, serious bodily harm to self, or homicidal violent behavior towards others. This is going to be a fact-intensive inquiry and dependent on each of the cases, so it's important to have different protocols in place in order to evaluate whether or not a likelihood of serious harm is likely, in which case there would trigger the obligation to report. And then finally, the immunity standard, which is protection from civil and criminal liability. The professional has to use reasonable professional judgment and act in good faith in making that determination. So making sure that you're adhering to the different protocols within the community that are known and acceptable within the community, making sure to discharge all of those different tools and protocols. Okay, so the next slide goes over the scenarios where New York law gives the authority to warn, but it's not necessarily the obligation to warn. And there's a number of different statutes that deal with it, but I mentioned one, and that's New York Mental Health or Mental Hygiene Law 33.13C6. And this really dovetails with the duty to warn in the TerraSoft and in the previous slide, where it sets forth a serious and imminent danger to that individual. So that same language appears elsewhere in New York law, although this time it's just the authority to warn, and it coextends with the obligation to report. And I would note that this specific section applies only to psychiatrists and psychologists, which is why there's all these different statutes that kind of all live together, so to speak. So the next question is, to whom does the practitioner owe a duty to warn other than law enforcement, for example? And generally speaking, the more particularized the threat, the more likely the duty to warn exists. And that's because, generally speaking, the duty runs only to the persons who are threatened by the patients who are readily identifiable. And that language comes from the TerraSoft case that I mentioned earlier. But other factors may play a part, such as if the endangered individual already knows of the threat. And this is best exemplified by looking at a few cases. The first case, Wagshaw, the patient was a voluntary outpatient client who had not visited the facility for months prior to the shooting. So again, you're looking at, one, whether there was control, and then two, if there's a duty to warn. There, the court held that there was no duty to control, again, outpatient clinic, and also no duty to warn. And the reasoning behind that was the plaintiff was the patient's husband, or the plaintiff, was the patient's husband, and he was well aware of the threat because he was himself one of the victims of his wife's attacks on prior occasions. So there, the court held that because the patient or the plaintiff was already aware of the threat, there was no duty to warn. The second case that I've put on the slide is Adams versus Elgart. There, the court held that the plaintiff was not at a particular risk since the patient had not specifically threatened the plaintiff, and the court held that there was no duty to warn because the plaintiff was the one who, again, advised the defendant of the prior incident in which the patient had exhibited the violent propensities. So again, where the plaintiff was already aware of the threat, even though it was a single person, there was no duty to warn. And in the third case, Huntley, this was a little bit of a different scenario. The failure to warn about the suicide plans of the patient to a staff psychiatrist who controlled the patient's leave privileges did render the hospital liable for negligence. So this was a case where a duty to warn was found, and it kind of coextends and relates to the duty control because the patient was an inpatient getting treated there for inpatient purposes. So that's sort of a few examples of how the duty to warn can manifest in different circumstances. Again, many courts have hinged on the outpatient versus inpatient, but also the measure of control over the patient. And before I leave the duty to warn, I just want to mention the interplay with HIPAA, which I know your handouts cover, and I think will be part of a future privacy workshop. But to the extent that the provider determines that there is a serious and imminent harm, and if you could go to the next slide. The HIPAA permits a provider to warn the appropriate person or persons of the threat, and that's consistent with professional ethical obligations and state law requirements. And that specific section is set forth in the federal regulations. Obviously, state obligations, as we said before, differ, but this language is consistent with language in the New York statute that I mentioned. And even where danger is not, quote, imminent or a serious and imminent threat, HIPAA does permit a covered provider to communicate with a patient's family members, for example, or others involved in a patient's care to be on watch or to ensure compliance with medication, as long as the patient has been provided an opportunity to agree or object to the disclosure and no objection has been made. And that's another example of where HIPAA could allow for potential disclosure, and that's because that specific section requires disclosure and an opportunity to object. And an advanced waiver might come into play in that scenario, and I know Sylvia will talk a little bit more about that later. With that, I'll move on to the next duty that a practitioner may owe, and that is the duty of competence. And even practitioners who are not licensed professionals may owe a duty of competence. And an example of that is in Webb versus Mueller, which I've put up on the slide. There, Mueller was charged with, and Mueller's, I guess, the practitioner in this scenario, was charged with interviewing students potentially at risk of self-harm and then deciding which university services to invoke according to policy guidelines. That could mean anything from outpatient mental health counseling or contacting the police to conduct a more intensive inquiry and to look into the threats of self-harm. The court there held that ordinary principles of negligence applied, and basically requiring that the practitioner act reasonably in executing the policies designed to prevent students in crisis from acting on expressions of suicidal ideation. So again, this kind of dovetails with the concept that even if a duty to care does not attach to the relationship at the outset, the duty may arise from the voluntary assumption of responsibility, and that a duty of care and a responsibility to act reasonably would apply. So the next area, it's related to this duty of competence, is the area of malpractice. And typically malpractice is tied to professional obligations or the professional obligations in ethics, but the crux of the medical malpractice is that a plaintiff must show that the defendant deviated or departed from accepted community standards of practice, and that such departure was the proximate cause of the plaintiff's injuries. Now, I'll mention that one of the limitations of a malpractice claim is standing. And as a general rule, only the patient has a standing to sue. So only in special circumstances would a non-patient be able to sue a practitioner for malpractice due to any injuries that plaintiff may have suffered. So the burden of care in a malpractice action involves the plaintiff establishing that defendant, again, deviated from acceptable medical practice and that it was the proximate cause of the injury. The defendant's responsibility then is showing that there was no departure from the standards of care and that the deviation did not injure the plaintiff. And this is an important concept to remember in this, is that physicians are not generally liable for mistakes in professional judgment, but they have to do what's best, what they think is best after a careful examination. So the only way that liability would be able to sue is if your judgment is not based on intelligence and that there was a failure to exercise any professional judgment. So important to that is actually, doing the examination and being careful and prudent in the diagnosis as well as the treatment. With that, I'll turn next to the next element of the negligence claim, which is causation. And that's true for both negligence commonly as well as malpractice. I think the important thing to remember with causation is that even though the acts of a third person may intervene between the defendant's conduct, so the practitioner's conduct and the plaintiff's injury, and that can be, the patient himself or some third party who may have encouraged the victim to carry out acts of violence, the causal connection is not automatically severed between the practitioner and the plaintiff's injury. In that case, liability really turns upon whether the intervening act, so the act by the patient or again that third party, is a normal or foreseeable consequence of the situation created by the defendant, so the practitioner's negligence. And if the intervening act is extraordinary or not foreseeable, then it may be considered a superseding act that actually breaks the causal nexus. If it is foreseeable or is not so far removed from practitioner's conduct, then it may not break the causal nexus. And so much of this will be dependent on the facts, and actually a lot of this will involve expert testimony, because experts can kind of go and dive into whether or not, and kind of determine which factors contributed to the actual violence and the damages. I only mention it because I think there's a common misconception that just because the patient committed the violence and not the practitioner, that doesn't mean that the practitioner cannot be considered a legal cause of ensuing damages. A final point that I will mention before I turn this over to Sylvia is that of judicial immunity. And to the extent that the practitioner is appointed by the court to carry out the prevention services, there may be an argument that judicial immunity applies. And judicial immunity is important because it precludes the plaintiff from recovering damages for negligence or malpractices against them. And I put up a case where that was an example. And again, it's going to be dependent on the relationship the practitioner has with the courts and how much of that was determined and directed by the courts. So with that, I will turn it back over to Sylvia to talk about insurance and waivers. And of course, if there's any questions, we'll be happy to answer them.
Thanks, Stephanie, and thanks, Ben, as well. I had them take me off the video because I was interfering with the shared screen, so hopefully somebody will show up and put me back on the screen at some point. So you've heard about some statutes and some judicial doctrines that can provide some at least minimization of risk of liability or damages, if not complete immunity. But in addition, you may be able to minimize some of your liability risk and damages risks, even if you can't totally eliminate them by contract. Now, obviously, you can't contract with victims who may be injured in a future unknown terrorist attack by somebody that you've treated in an intervention program. But that's why you need statutes and judicial immunity to try to deal with that risk. But you may be able to minimize your liability risk with the actual participants in the program who may, as Stephanie just indicated, have a claim for medical malpractice if the treatment doesn't work, for instance. You may also be able to possibly do it, at least to some degree, through the referral papers of courts and referring agencies. And this is something you really should talk with your own legal counsel about trying to see if that's a possibility for you. But there are some general principles you ought to be aware of, particularly as you talk with your own legal counsel. Advanced waivers of liability are waivers or releases of claims before the events happen that caused the injury and created the potential liability for the injuries. We've all signed those every time we got on a roller coaster ride at a theme park. Probably have signed them when we parked our car at the airport. It's usually in the fine print of those documents. But such advanced waivers, advanced releases of claims are disfavored in the law, and in some instances they're actually void as against public policy. In most jurisdictions, for instance, a parent cannot give an advance waiver of liability for minor children. That's unenforceable, usually just as a matter of public policy. The concern is obvious. It's with the fairness of somebody who may be seriously injured or may even be killed as a result of the negligence of another person, and yet has waived any rights with respect to that negligence before they could possibly know all the facts bearing on the decision to grant a waiver. But that said, if the language is clear enough and unequivocal, and there's some benefit in legal jargon, some consideration to the person granting the waiver, such as the agreement perhaps to provide mental health services at no cost to the participant or at a reduced cost, then such waivers can be enforceable. But as I just mentioned, they must be explicit and they must make it clear on the face of the document that the party is waiving any claims for personal injury or property damages arising from the other party's negligence and failure to use due care in the services, mental health services, or conduct of the intervention program. If possible, the document should recite the releasing party's awareness of the risks associated with the subject of the waiver and specifically state that the person assumes those risks. Here, such risks might include failure to comply with the conditions set forth at the outset of the program itself. Such waivers are most likely to be enforceable if they're limited to a waiver of damages caused by negligence, but not extending to damages caused by gross negligence or intentional acts of wrongdoing. Trying to escape liability for those kinds of damages, as you would properly expect, is very, very difficult. Likewise, however, waivers of consequential damages, such as perhaps loss of profits to a person who can't continue in his or her business, are likely to be enforceable. The consideration, the benefit, the quid pro quo to the releasing party should be spelled out, and the more you spell it out, the better. And you may want to include some disclosures about the absence of any assurance of the success of the intervention and the mental health services. As Stephanie indicated, New York no longer recognizes a general charitable immunity doctrine that shields charitable institutions and organizations from claims by those who get the benefit of those services. But other states do have such statutes and doctrines, and so you need to look into that if you're in a state other than New York. You should also consider the possibility of seeking arbitration agreements with participants and agreements for waivers of jury trials, maybe pre-suit mediation. These types of agreements are going to be actually favored in the law as opposed to resort to litigation. And so if they're properly written, they can really minimize your litigation defenses. Ben talked about the MGM litigation where the potential defendant from claims of victims hastened into federal court with an effort to get federal court jurisdiction by a declaratory judgment, and that's because most defendants would prefer to be in federal court rather than state court. That's not always the case, but is often the case, and so that's a benefit of the Safety Act. I have to say, as an aside, that as I was listening to Ben talk about the Safety Act, what came to my mind was a issue that is being under great discussion in legal services, which is whether our current newly constituted United States Supreme Court is poised to limit the discretion of administrative agencies and poised to eliminate the long-standing, ever since I've been practicing law, deference that courts have provided to agencies' interpretations of the law. And so there's some real issues, and I'll come back to that in a minute, with respect to that act that we may want to be discussing with Congress. The best defense to liability risks for you guys is documentation, is writing down what happened, what you did, why you did it, whether the participant in the program cooperated, didn't cooperate. Juries, we have found over and over again through jury research, believes that if something isn't written down by a medical provider, it didn't happen. And so that's the best advice I have to you, other than to get a lawyer to work through all these issues with you personally. And so finally, obviously, the best for everybody is if we are able to get some statutory protections with respect to third-party victims. As I was listening to Ben talk about 500 people being injured, not even putting aside how many were killed in that massacre, to just think of the litigation and not just the cost of defending it, but the time and expense of your people in defending it. So obviously getting some statutory initiatives is something that needs to be explored, and to try to fix, if possible, some of the questions that were raised in the MGM litigation with respect to whether the Safety Act applies in certain instances or not, particularly with respect to the issue of insurance, which can be problematic, whether you can get any insurance at all, much less at a prohibitive price. And so with that, I'll turn it over to Richard, who is going to, I hope, come back on the screen. And while he's talking, I'm going to see if I can come back on the screen before questions and answers. Richard, there you go.
Thank you, Sylvia, so much. Thank you, Ben. Thank you, Stephanie. That was an amazing presentation. I feel like I've just finished the first 6 months of law school, which I really did need to do again. I just really appreciate it. We've had quite a few questions. I will say some of them were pre-submitted and actually are applicable to subsequent webinars that we're going to be doing. So I'm not going to bring those up in this section. But I do want to start with a question that's coming up around legal structure. As one listens to you speaking, one is probably sitting here thinking, oh my God, am I going to be sued? I, the practitioner. I'm providing trainings, I'm providing threat assessments, I'm providing mental health services. But maybe you could talk a little bit, Ben or Stephanie, about what the legal structure in which you operate, the protection that may offer you, and how that protection can be whittled away.
Stephanie, do you want to take a swing at that? Or I can say with regard to the Safety Act, the extension of the Safety Act's protections extend to the seller and the seller's customers. If the customer of the seller is an entity, then I would think that the Safety Act's protections would extend to that entity, so that were a person sued in their individual capacity rather than as an employee of an entity, I could see an argument that the Safety Act's protections would not extend to that individual. But it's very hard to say. These are all very case and fact specific questions, and speaking about it in the hypothetical, you can only really make a guess, I think.
Right, and I would add that it would depend a lot on the relationship and the contract that you have or the participant has with the practitioner, whether it's with an entity. So for example, if in a normal doctor-patient relationship, perhaps you are getting services by a group, a doctor's group, then both the doctor's group and the individual could be potentially open to liability. But a lot of the times you'll see that practitioners and doctors will have professional liability insurance, and that provides a measure of protection. And additionally, I mean, typically speaking, the contract will determine the terms and kind of frame the relationship between the parties. And so that's sort of a key document to make sure that you're looking at, and making sure that you have an attorney consult on what the the terms in the actual written agreement look like. And as Sylvia mentioned, if there's any limitations of liability or different disclosures that you make, that includes, mentioning any duties to warn, and that, the practitioner may have to, in some case, break the confidentiality of the patient for certain circumstances in which the practitioner feels that there's a serious and imminent threat of harm.
And I'm assuming, Stephanie, that thought would also extend to the more elementary questions about making sure that whatever corporate structure you have, whether you're a not-for-profit or a for-profit, is being suitably maintained. Each state tends to have particular requirements about what's needed to maintain your corporate structure, and not-for-profits are corporate structures.
Absolutely. Nonprofits are not, as a general matter, exempt from litigation. In fact, I think there's lots of litigation involving nonprofits. The concept of making sure that every document is sort of buttoned up from a corporate structure is absolutely applicable, although it doesn't necessarily tie into the negligence. It could sort of be a different type of leave you vulnerable to a different type of attack than just pure negligence. But it's something that perhaps could be used as a fact to sort of hurt you in a way, and what we call in litigation, dirty up the other side. They could say, well, you're obviously not complying with all these other obligations, then you're probably not complying, and it just hurts your credibility if you're not sort of dotting your I's and crossing your T's with respect to your corporate structure as well.
In other words, be sure to keep your corporate house in order.
Yes.
To be really cautious about that. I should note regarding Ben's presentation that we, meaning at the Crime Commission, are exploring whether or not the Safety Act is applicable to the providing of mental health services. I don't know that it's clear that it is, and I don't know that it's clear that it doesn't. I suspect it's still an open question unless something has changed in the last 6 months or so. And then making the secondary judgment about whether or not it's financially worth it given the insurance requirements. So we're looking at that and discussing it with some of the people in this network. The next set of questions actually come about in a sense because of COVID and the lockdown, and they revolve around the provision of these sorts of services existing in an online environment as opposed to an in-person environment. And I'm wondering if any of your assessment, if your analysis of your guidance, particularly what Sylvia just said, changes because somebody's operating in an online environment as opposed to an in-person environment. In other words, providing mental health services, for instance, online through whatever mechanism, as opposed to in an office.
I wouldn't think that would have any effect on my analysis under the Safety Act, so long as that was described in the application for the designation. It's hard to say. Again, I think as Sylvia pointed out, leading into this, you're probably going to get a lot of maybes, and it depends. Answers to these questions, but it doesn't seem like, at least if we're talking about it in the context of mental health treatment, and in every other respect, the provision of the treatment conforms to the description of the service that would be provided that was approved by the secretary. It doesn't seem to me like it should matter whether it was over the internet or not, but without having a concrete example, there's infinite possibilities. There of course there could be an instance where it would make a difference, but if your actual application for the designation or certification described that possibility and you got approval, then absolutely I don't think that would have any effect.
And I'll just jump in. I think that Ben's right that the even as to general sort of liability principles, your obligations to provide adequate and reasonable care still apply over, the internet if you're doing a virtual consult, but also to continue to exercise professional judgment. So if there's a circumstance where it would make sense and it would probably be better if there was an in-person interaction, then that's a judgment that you could document and state that the need or the not need, I guess, or the for whether or not an inpatient or in-person, excuse me, a session would be needed or more appropriate. Also, there are HIPAA concerns with doing things over the web and doing things virtually. So to the extent that you are talking about, obviously, protected information, make sure that your media, so your whatever platform you're using is HIPAA compliant, and that you're taking protocols to make sure that no third party is able to sort of overhear, or you're not, recording in a way that it can be disclosed that's in violation of the patient's privacy. And similarly, if there's a need to get consent for that, then certainly that's something you can just say up front, saying that, we're going to do this consult virtually. If there's any reason for you to be concerned, you're at least being made aware of the risks that, someone could get hacked and something like that, an intervening cause. But largely, I think the obligations remain the same, with the additional caveat that I think that you have to be careful of any virtual disclosure due to HIPAA.
I should also note something else that's somewhat relevant to this question, but probably beyond the scope of this presentation. And this is not a question that I asked you to look at, so I'm not trying to catch you by surprise here. But I have noticed that a lot of mental health professionals, all of whom are licensed under state law, have become more transient and are moving to different parts of the country and still providing mental health services, which, to use a federal phrase, across state lines. I don't really know what the licensure law is around that. If you're a New York State mental health professional and you decide to move to Florida for the pandemic, what responsibilities you have to contact your own state authority, whether or not you're actually allowed to do that, and what impact that would have on what state law is involved should there be an injury. It's probably the state law where the injury occurs, but that is something for people to be thinking about. But again, I did not ask you to look at that, so I wouldn't expect you to respond to that. Another series of questions came in around exactly what Sylvia really nailed towards the end of her last presentation, which was, to phrase this in a catch-all, what can one do to best protect him or herself? And Sylvia, I think your answer was write it down, write it down, write it down. Do you want to augment that at all? Is there other things that you might want to add? We had quite a few questions around that, understandably. You're muted, Sylvia. Sylvia, you're muted. Sylvia? Sylvia, you're muted. I don't think she can hear us.
I'm pressing the ask to unmute button.
Okay. There you go.
There we go.
There you go. Thank you.
There it goes. Okay, thank you. I'm sure everybody has now grasped that I write my legal briefs with a pen and paper. I'm way back in the old last century. It was also something I was going to add with respect to the very good question about online services, and that's the importance of making sure that if there are protocols that you're following those general protocols, because it's deviations from the general practice that's going to create the greatest risk for you. In the legal profession, as soon as we shut down in-person hearings and trials, many protocols were developed for virtual hearings and virtual advocacy, and how to assure that you maintain privacy of sealed documents when you're sharing documents on the screen and the like. And I think that's going to be the same both for online services or in-person services. So I would encourage everybody that to not only document what they've done and what they didn't do, and document what the participant did and didn't do, but also try to document it in the context of protocols that may have been developed in the mental health community for either these kinds of services to potential terrorists, and particularly more generally for online services.
Thank you. Stephanie, this is actually particularly, I think, for you. And this is a pretty specific question, which is, actually, I'm just going to read it so I don't misstate it. What's the process for determining who is warned in the duty to warn? Does it have to go through law enforcement, or are there other mechanisms that allow third parties to intervene first? And I just will state, before Stephanie has to do it, this is probably pretty much a creature of state law. So one should be aware that whatever answer she gives, is not necessarily final in every state.
Right, and it does depend on state law, but it also depends on the facts of the case. So who is warned? Again, it's sort of within, depending on the statute. For example, in New York, it requires disclosure to anyone who potentially would be harmed or to law enforcement. But it doesn't really go further than describing that. So it's left to the practitioner to and with counsel if needed, to within this, the given facts of the patient's, whatever the threat may be, to determine who is the appropriate person to warn. I think law enforcement is sort of the easy one, because you can contact your local or state police, and maybe they can they'll tell you, well, this is more appropriate to be said to the federal agencies or to a local agency, something of that nature. When you're dealing with non-public entities, so for example, you're trying to warn the potential victim, I think that's obviously you want to document and make sure that you're doing so in a formal and kind of regimented way, as also not to create further issues. So I think developing procedures and trying to consult with perhaps your colleagues on who might be the appropriate person and how to deliver that message is going to be important, again, on a case-by-case basis, because of the sensitivity of the matter, generally speaking.
So I'm going to ask this last question, then I'm going to open up to the floor here. One person noted that there were lots of cites to New York cases. The reason that happened was because this is so much a creature of state law as opposed to a uniform federal law. We just decided to focus on New York. The crime commission's in New York, and it just seemed like a good state to use to illustrate these various principles. One of the reasons is it's so litigious. It's a very litigious state, both in the federal courts and in the state courts. But the person also asked if you have any favorite reference books or articles or go-to resources for either other states or for general principles, particularly around duty to third party, which is
Richard,
the theme of the questions.
Can you hear me?
Yes, we can.
Yeah, that question is a great question, and it reminds me of something I meant to say and did not. Another reason for using New York law was that New York law honors the restatement. And the restatement is a legal document. It's called the Restatement of the Law, and it's a heavily vetted document by both judges and lawyers, and is adopted by most jurisdictions, not all necessarily, and not all of the restatement is necessarily adopted, but tort law particularly often is grounded in principles that are set forth in the restatement. So by using New York law, we thought, which follows a restatement, we thought that that would give them the most general overview of what is likely to be the law of other jurisdictions.
All right, that's actually a great point. I'm sorry I didn't mention that. So we're going to just try and throw this open to the floor. If you have a question, just go ahead and ask it, and we'll just maintain a natural order of things here. If it gets unruly, I'll step in. Does anybody? Just flip your camera on, flip your mic on, and ask away.
Richard, Jim made a good point in the chat with respect to licensed clinical social workers practicing. So I just wanted to flag that for everyone's awareness.
Was that sent to everybody?
It was.
Okay, good, great.
Yeah, I posted it to everyone in the chat.
Okay, great. Anyone have any other questions? Gosh, you're never a shy bunch. Anything? James, were you raising your hand? No, you were fixing your glasses. Okay. Well, I want to add another round of thanks to you three. This has been just outstanding. You've done just an enormous amount of work. These presentations were super clear. It's complicated areas. Thank you, thank you, thank you. Brett, do you want to wrap up? Welcome back. I'm glad to see you're not having a reaction. Do you want to wrap up?
Thank you, everyone, so much for joining us. A special thanks to the Carlton Fields team and Richard for facilitating in a pinch. We really appreciate it. Please, everyone, this is the most theoretical of these workshops, and we are working our way to practice. So the next workshop will be addressing criminal liability and potentially also insurance. But then the third workshop in this series, that's where we take all of the concepts that you learned today and in the next workshop and actually apply them to cases. So apply them in practice, understand how a social worker, for example, might interpret their duty to protect or duty to warn in practice in the context of a hypothetical case. So I think that workshop will really help drive these concepts home and understand how to apply these concepts in practice. Addie has gone ahead and posted our post-workshop questions for you here. We did get a question in the chat as to whether or not this workshop would be recorded. The answer is yes. It will be made available on the McCain Institute website. I put the link to that website in the chat. And the videos of all of our prior workshops are available there, as well as all of the fantastic read-ahead materials prepared by the Institute for Strategic Dialogue. Please go ahead and answer these post-poll questions and consider signing up for future workshops. We welcome you to share these links and these workshops across your network, and we hope you find these resources helpful. Addie, are there more questions we need to get to? Should I keep talking? Or are we good?
Yep, that's it. Just the one. It's simple this time.
All right. Thank you, everyone, so much for your participation today. Thank you again to Carlton Fields and to Richard Aborn. We look forward to seeing you next time.
Thank you all.